Hi, everybody. Andy Nelson. So I was recently asked if there was any such thing as a poor man's trademark. Now, what does that mean? This is kind of a permutation on a concept you may have heard before, a poor man's copyright or a poor man's patent. The idea being, if you conceive of something and you mail it to yourself and don't open the envelope, keep it in a drawer, and if you ever get in a fight with somebody later about who came first, you've got the upper hand because you've got this infallible way through the U.S. Postal Service and a postmark of showing that you, in fact, came first. It doesn't really make sense in a trademark sense, and here's why. Think about this. So trademarks themselves are symbols, right? They're symbols of your brand, whether they're names, logos, trademarks, names, logos, slogans, maybe distinctive color combinations or packaging, things like that, that identify you as a single source of goods or services, distinguish you from competitors, as a source of goods or services. So how can you really think up a great name for your company or, great logo or whatever, tuck it away because you're not ready to move forward, you're going to use it later, somebody else does something similar or identical, and then you come up later and say, no, I was first. I have superior rights to you because I was first. That doesn't really make much sense, right? Now, it's kind of a first in time, first in right sort of regime. So the idea is if you use your trademark or trademarks, and they're distinctive and they don't stomp on someone else's rights at the beginning, use them in commerce, you are going to be a senior user. And at that point, you're going to be able to exert or claim senior rights over somebody who's a junior user who uses or begins to use something that is likely to lead to consumer confusion about source, sponsorship, or affiliation. So that has to really be public facing. So there's no real, poor man's way of, mailing something to yourself that's going to give you superior rights. However, since I got a moment here, there is, if the idea is there a cost savings way to obtain a trademark? The answer is yes. A lot of people think that you have to get either a state registration or a federal registration and pay those costs in order to have trademark rights, and that's a myth too. Trademark rights in the U.S. in every single state are created by using distinctive trademarks in commerce correctly, in connection with your goods or services correctly, and not stomping on somebody else's. And of course, they need to be distinctive. They can't be generic terms. And there's sorts of things, but that doesn't cost anything. That is free. Okay. So in that sense, there's a poor man's trademark in that, or a poor person's trademark in that you can just start using them. The other method, I won't go into it again. It's not true. It's a myth. But there is a low-cost way to begin to establish trademark rights. But I will say, let me be clear, why you don't have to get a state or a federal registration. Those registrations, particularly the federal ones, state ones, the federal one makes or can make, if you're able to obtain it, your rights way stronger, much stronger than just the kind of free use acquisition or way to acquire trademark rights. Anyway, that's it. If you have any questions about this video, drop me a comment, shoot me a note, and if someone would benefit from the contents of this video, please feel free to share it. Until the next one, have a good one.